If it's okay, I'd like to address the court.
Well, you understand that possession of marijuana by itself carries up to 6 months in the county jail and a $1,000 fine, or both?
I do. Sir, I understood that it was my understanding that it had been decriminalized in the state of Kansas. Now I think that's just the city of Wichita. So I was unaware of that. Obviously, that's no excuse, but I'm not like some stupid stoner. I own a business. I employ people. I smoke a single joint at night so I can sleep.
Okay.
That is literally.
You don't want to go any further with that right now. All right, Mr. McCoy, before I could accept any pleas of guilty and accept your statements of conviction in the case, you would have to waive your right to legal counsel in the case. You do have a right to legal counsel. If you can't afford one, the court will appoint one for you. Are you sure you don't want to talk to a lawyer about this?
Well, how much trouble am I in actually? Like, would you actually sentence me to jail for this? It's a first offense.
This defendant walks into a Kansas courtroom thinking he can out-talk the law, outmaneuver a judge, and explain his way out of an active warrant, all while casually downplaying multiple criminal issues stacked against him. And from the very beginning, you can feel it. He believes confidence will substitute for accountability. He's armed with excuses, half-truths, and a running narrative where none of this is really his fault. But here's the problem. The judge already has the paperwork. And once the facts are on the table, this entire story starts to unravel fast. What begins as a simple marijuana and traffic case suddenly turns into something much bigger. A probation violation, a fugitive status, and a Nebraska felony that never actually went away. Every time he opens his mouth, he reveals more than he intends to. And instead of minimizing damage, he keeps digging. This is the kind of courtroom moment where reality crashes headfirst into ego. And by the end of this hearing, you'll see exactly how quickly excuses collapse when a judge refuses to play.
Well, I'm not going to plea bargain the case with you here.
Understood. No, understood.
What my sentence might be. The B misdemeanors are punishable by up to 6 months in the county jail and up to a $1,000 fine apiece. No valid driver's license is a Class B misdemeanor as well. And speeding is punishable by a scheduled fine, but it could be up to $500 theoretically.
So I'm fine with the fines. The only reason my driver's license is not valid is because I was out of town working.
Okay.
And I didn't realize it was expiring. And so I was literally on my way back in town. I haven't had a chance to get it validated yet, or get it renewed,
Okay.
It's not like I was intentionally driving without a license.
All right. Before I readdress the issue of potential waiver, waiver of counsel, I want to address the other matter that concerns you. State of Kansas versus Dennis J. McCoy, case number 2023 MR 59. Apparently, that's a fugitive information. Based on the information before the court, Mr. McCoy, Sarpy County, Nebraska has made a demand for your surrender involving a charge of controlled substance possession of cocaine, a Class 4 felony in case number CR 19561, stemming from allegations from incidents which allegedly took place in October of 2020.
Yes, sir. So I went to court for that, and I was assigned probation. When I went to the probation office, they said, okay, I made it clear that I was not a resident of the state of Nebraska, and they said they were going to try and transfer my probation to Sedgwick County. The probation officer called the Sedgwick County probation's office. They said because I had pled it down to a misdemeanor, that they would not accept the transfer. They were only accepting felony probation transfers.
According to the paperwork before the court, Class 4 felony is listed, not a misdemeanor.
And so that was the original charge. I had made a plea bargain.
Okay.
I pled guilty in exchange for a misdemeanor. I went to probation. They gave me 2 years, and then the Sedgwick County wouldn't accept the transfer. The probation officer comes back to me and says, I don't know what to do about this, and the judge is left for the day. I was told I could go home and that they would call me. They never called me.
Right here is one of the most common courtroom myths, confusing city policy with state law. The defendant confidently claims marijuana was decriminalized, only to immediately backpedal when the judge clarifies it's limited to Wichita. That hesitation tells you everything. He didn't research the law. He heard something, assumed it applied everywhere, and rolled with it. Courts don't operate on vibes or misunderstandings. They operate on statutes. And notice how quickly he pivots from legal argument to personal branding. Suddenly, he's not some stupid stoner. He owns a business. He employs people. He only smokes one joint at night. But none of that matters. Courts don't issue exemptions based on self-perceived responsibility. The law doesn't care how productive you feel. It cares whether you complied.
The real question, Mr. McCoy, is do you want to arrange for your own transfer back to Nebraska and deal with this? That's what we call a waiver of extradition. Instead of requiring a governor's warrant to be issued, you would just simply agree to waive extradition procedures and instead agree to voluntarily go back to Sarpy County, Nebraska, and face whatever it is that you do face there. Do you want to
Am I
consider
able
doing
to
that?
go under my own strength?
I don't see any indication here there's a bond. So I think my answer would generally be no.
And there's no way we can work around that. Like, I own a business, I employ people. Payroll isn't going to happen if I can't get out of here. I have projects starting that are going to completely flop. Is there no way for me to do like house arrest and wait for them to come and get? I realize you guys are required to hold me and give Sarpy County the opportunity to come and collect me. Is there no way that can be done from like house arrest? So I can still run my business? I will lose absolutely everything. I'll lose my home, I'll lose my business, I'll lose my vehicles. Like, is there no way we can come to some sort of resolution where I'm still held accountable yet able to continue running my business? I employ about 33 people that will not get paid on Friday if I cannot get out of here and do payroll.
And there it is, the lie that collapses everything. He tries to play the first offense card, but the judge immediately shuts it down with receipts. You don't get to claim this as your first run-in with the law when you're literally sitting there on a probation violation with an active warrant. That contradiction doesn't just weaken his argument, it destroys his credibility. In court, credibility is currency. Once you lose it, nothing else you say carries weight. The judge doesn't need to raise their voice or lecture him. The facts speak louder. This is why honesty matters, even when the truth looks bad. Because once the court catches you minimizing or misrepresenting your record, every explanation after that gets viewed through a skeptical lens.
Not to mention I will lose absolutely everything that I've spent the last 6 years busting my butt for. I work 300 days and some change a year. I'm home 1 to 3 days a month. I'll lose everything. I'll lose everything.
All right, so my question again is, do you wish to waive extradition and agree to return to Sarpy County, Nebraska to face whatever it is that you do face there on this probation matter?
What does that mean? Can you tell me what that means exactly? What's the other option and what does that mean as well?
You would be held in jail and then you could require Nebraska to go through extradition procedures and seek a governor's warrant.
Okay, and the other option?
I mean, like what?
I thought you said I had two options.
Yes, either force Nebraska to go through extradition procedures or do a waiver of extradition, which is a voluntary agreement to return to the state of Nebraska and face.
And will you guys return me to Nebraska, or do I have to wait for them to come and get me?
You're probably going to have to wait for them to come and get you, and they probably aren't going to come and get you as long as you have this Kansas case pending.
So again, I ask you, is there any way to do this from a position of house arrest so I can continue to run my business?
Okay, my answer would be no. Not as far as Nebraska is concerned.
I'm just going to lose everything.
Well, all right. That's not involved here, Mr. McCoy. I just have business I have to conduct.
I understand that, but I'm trying to find out if there's a way for us to come to some sort of agreement wherein I don't have to lose absolutely everything.
Okay. Well, I'm obviously concerned about your Kansas case because of the way you handled the Nebraska case.
And I can understand
this probation case December 30th, 2019, and it's still pending. You never did
And
take
that's because I tried to deal with it, and they said I could leave, and they never called me back. I called them. They said, we'll call you back again. They never called me back. And then 11 months later, I got a warrant out of the blue. When I got the warrant, I called them and I said, hey, what is this about? I've been waiting to hear from you guys. They kept demanding I give them my location so they could have me picked up, and that I come turn myself in immediately. And like, this all just spiraled out of control. When I went to court twice and the probation office immediately after I was given probation in an attempt to deal with this, because I didn't want exactly this to happen. I didn't want this hanging over my head. I'm trying to take my business internationally, and I can't even get a passport renewal. So I just turned 35. When I turn 35, my trust fund is meant to distribute me $150,000. I was going to take that opportunity to deal with Sarpy County. I never intended not to deal with Sarpy County. I just had to do it from a position where I wouldn't lose everything I've worked for. So I need to get this distribution. I need to set it up in my account so I can have everything auto withdrawal from that. And then I'm free to go. Sarpy County can throw me in jail if they want. But everything on my end will be secured. Right now it's not, and I'm at risk of losing absolutely everything. I'm willing to do whatever it takes to get all of this resolved as neatly and as orderly as possible. I never intended not to deal with Sarpy County. I just had to do it from a position where I wouldn't lose everything. And now I'm right back in that position anyways. I'm not here to run. I want to cooperate, and I want everything accomplished so I can put all of this behind me and just move forward with my business, with my life. I'm so close to financial independence, and that's all about to disappear.
All right, Mr. McCoy, regarding the Kansas case, 2023 CR 323, the marijuana, paraphernalia, no valid driver's license, and speeding case. Are you wanting to waive counsel and enter a plea today? You don't have to. I recommend against it, but you communicated earlier that that's what you wanted to do. I just want to.
Yes, I would like legal counsel.
All right, very well. The court will appoint Darren Patterson to represent Mr. McCoy.
Can I get my own lawyer?
You can.
I have a lawyer. His name is Eric.
Who's your lawyer?
Eric Kidwell.
Okay. You can
I don't
certainly
believe
get
I have
Mr.
him on-
Kidwell to represent you.
Say again.
You can get Mr. Kidwell to represent you if you want to. I just want to make sure the next time you see a judge on this Kansas case, you have a lawyer. Now, if you tell me you've got the resources, apparently you do, and you're going to hire a lawyer, then we'll go with that. Is that what you want to do, Mr. McCoy?
That is what I want to do, but I'm
All right.
curious how I'm supposed to do that from in here.
Actually escalates. What started as a local Kansas matter suddenly becomes interstate and serious. A demand from Nebraska, a cocaine charge, a Class 4 felony, and a probation violation stretching back years. That's not a misunderstanding. That's a legal time bomb. Listen carefully to how he explains it. Everything is passive. Things weren't accepted. People never called back. He was told he could leave. But probation doesn't work like that. When you're on probation, silence isn't permission. It's a warning sign. The responsibility to follow up, comply, and stay reachable is entirely on the defendant. Judges hear these stories constantly, and they almost always end the same way. Paperwork doesn't vanish because communication was inconvenient, and warrants don't disappear because someone hoped the problem would resolve itself.
There's a bond in my Kansas case, as I understand it, correct?
I haven't set one yet.
Oh, I was told there was a $3,000 bond when I was booked in.
I don't know where that comes from, but it's very possible the jail
Set a bond on there.
schedules. Your position that remaining the bond, Mr. Regier?
Your Honor, I don't know about any bond that's already been set in this case. If the court is prepared to set a bond, state would suggest that $3,000 is relatively minimal. In addition to the Nebraska case, which the court has already referred to, my understanding is that this defendant does have some prior failure to appear history in Kansas as well. If
That was when I was a kid. I am not going to fail to appear.
Don't talk over me, please.
I'm sorry.
I'll set bond in the Kansas case at $3,000 cash or professional surety required. show that he's going to retain counsel, most likely Eric Kidwell, but he's going to retain counsel. And the date that I have for the misdemeanor docket is October 2, 2023 at 9 o'clock a.m. October 2, 2023, 9 o'clock, Judge Webster's Court. So at this point, there's a not guilty plea entered on behalf of the defendant, pending further proceedings in October. All right, moving to the extradition case. I don't see that court established any bond in the case. I get the impression, Mr. McCoy, that you're not wanting to waive extradition. Is that correct?
Well, how exactly does that work? I'm stuck in here no matter what, right?
All I know is that if you were able to post the bond in the Kansas case,
That I would be released?
no. Sheriff's normal protocols at the Sheriff's Department at the jail will contact Sarpy County, Nebraska, and I think some determination will be made whether you're going to be sent there or not. But a lot of times they're going to want you to have your Kansas case taken care of before you're shipped across state lines.
So does that mean I'm potentially being held until October?
Yes? Potentially.
Sir, I am not a criminal. This does not seem proportionate.
Nation sounds complicated, but the legal reality is simple. If you plead guilty to a felony with the promise it can later be reduced, it stays a felony until probation is successfully completed. You don't get to declare a misdemeanor early because it feels earned. Completion is the condition, not intention. What we're watching here is someone trying to reframe legal responsibility as administrative confusion. But probation is not flexible, optional, or negotiable. It's structured. It's documented. And ignoring it for over a year doesn't pause the clock. It accelerates consequences. 222222222222222. Now comes the emotional leverage, the business, the employees, the payroll. This is where defendants often hope sympathy will override procedure. But courts can't operate on hypothetical fallout. Judges don't weigh guilt based on how inconvenient jail might be. And notice something important. None of this was a surprise. The warrant didn't appear overnight. The probation didn't expire accidentally. These consequences were foreseeable and preventable. The court isn't destroying his livelihood. His choices put it at risk long before this hearing.
When Nebraska officials are notified, I don't know what they're going to tell the jail staff. Maybe their judge will set a bond for you in the Nebraska case. I do not know. What I just need to do, either it doesn't appear to me that you're in a position to waive extradition. So I'm going to go ahead and set this matter for another hearing.
What does that mean, not in a position to waive extradition?
Did you tell me that you wish to waive extradition?
I'm still not fully understanding exactly what this means.
Then maybe you need to have a lawyer explain it to you, because my attempts to explain it to you just haven't been.
So you're saying if I waive my right to extradition, then they can come and get me. If I don't, they have to jump.
You're eligible for that, but I do not know if that's what will happen. I make no promise.
Okay, I would like to waive it. I would fine.
All right. Do we have a waiver of extradition form that can be presented to him?
Yes, I do, Your Honor.
Thank you. Please read it thoroughly. If you have any questions, ask before you sign. I may not be able to give you an answer, however, to your question.
Am I still, is the sheriff's office here still going to attempt to see if Sarpy will set a bond if I sign this?
I don't know if they're going to attempt to see if they're going to set a bond or not. Normally, their protocol is to notify the Nebraska officials that you've waived extradition and that you're at least eligible for return. But you've got a Kansas case pending.
Is there no way to move up the trial of the Kansas case? Or can I not?
Your attorney can make that request.
How do I get an attorney from inside jail?
Talk to the jail staff about that.
Yeah, I want you at the podium. What exactly are you wearing?
I'm sorry.
You look like you have a swimsuit on to me.
No, it's not a swimsuit, and I did not know this was a court day. I just told the lady back there that I'm not dressed properly for court at all.
Really? Yes, you are not. I agree with that 100%. That's very insulting to me, that you would come into my courtroom dressed like that.
I apologize. I had no idea it was in as a visit and not a court date. So I was unaware that this was a court date. Because she wrote on the back of the car, a visit. So it was never said that this was a court date.
All right, this is case number 23CR40542, the state of Ohio versus Monique Smith. Ms. Smith, the court has received a report that alleges that you have violated the terms of your ILC. Officer, statement of the allegation, please.
Yes, Your Honor. Ms. Smith has violated ILC condition number 1, and that on June 11th of 2025, the defendant pled guilty to and was sentenced for 1 count of OVI and 1 count of driving under suspension. This was in Middletown. And then on June 11th, the defendant pled guilty and was sentenced for another count of driving under suspension under a different case number, also in Middletown. On December 10th, 2024, the defendant pled guilty to and was sentenced for 1 count of driving under suspension, or under an OVI suspension under a case in Middletown. And on July 12th, 2024, the defendant pled guilty to and was sentenced for 1 count of driving under suspension. As well as ILC condition number 8, the defendant has failed to inform her probation officer of law enforcement contact after picking up a new OVI charge and another traffic offense on March 24th of 2025. Special condition number 16C, the defendant failed to complete drug or alcohol treatment as ordered on February 1st of 2024. Special condition 16D, the defendant has failed to complete mental health treatment as ordered on February 1st, 2024. Special condition 16E, to date, the defendant has failed to pay restitution in full as ordered on February 1st, 2024. And finally, special condition 16F, to date, the defendant has failed to obtain her GED as ordered on February 1st, 2024.
Ms. Smith, do you understand those allegations?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you. Do you have the funds to hire an attorney?
I do not.
Do you want me to appoint you one?
Yes, please.
Mr. Mall's handing you an affidavit of indigency that you need to sign.
Okay. Right above my name.
Why is she not in custody?
All right, guys. In this section, the pressure jumps fast as the probation officer lays out a staggering list of violations.